So now we are going to move on to our next panelist. It's Anthony Gaeta, and we're going to talk about estate planning. You know, having all the value going up in real estate is definitely makes sense for you to talk to an estate attorney just to find out what is involved to make sure you have the best option. Hi, Anthony. How are you doing?
Hi, Simon. Doing great. How are you?
Bill, also. Sorry. Hi, Bill.
Hello.
Hi. So yeah, I head up the Gaeta Law Firm. We're a comprehensive litigation, estate planning, and estate administration firm. And what a lot of people don't realize about real estate is as soon as they close on their home, they've done a form of estate planning. They've done a deed. And we've noticed, at least in my practice, a lot of attorneys reflexively will give a purchasing couple, husband and wife, a deed that says joint tenants, tenants by the entirety, or joint tenants at rights of survivorship. And what a lot of people don't realize is that is planning. What would happen upon the death of the first spouse is the entirety of the title to the house will transfer automatically to the surviving spouse. Now you'd say, well, what's the big deal with that? It can be a big deal later, and it was a big deal in the past for a couple of reasons. One is New Jersey used to have a very onerous estate tax, something on the order of $675,000, and above that, you got hit with the tax. So that has gone away, but it may rear its head again. By titling your property, and we give this advice to almost all of our clients with rare exception, we tend to title the deeds, or ask that the deeds be titled by the closing attorney as tenants in common. And what that does is it gives you a level of control over your estate plan at the time the first to die spouse, at the death of the first to die spouse. So that allows you to put half that house at home's equity into trust. In tax planning, it was used for that purpose, but there's another purpose, which is elder law planning. So as we get older, what is a home? Really, it's our largest asset generally. We have forced savings into it where we pay down our mortgage and we build equity over time. Now, as you get up in years, let's say someone loses their spouse or life partner, and they're staring down the barrel of potentially going into a nursing home. Well, say on $1 million home, if you have joint tenants or with survivorship rights, that $1 million home is now completely in the name of the second to die spouse or the surviving spouse, and they'd have to spend through that $1 million before they became Medicaid eligible for a nursing home. So using planning through a deed and through the probate process, you can split that $500,000 and put it into trust, and it's protected from Medicaid, from creditors, and everything else. And then you can do some other sophisticated planning to make sure that's protected. But all that comes down to the deed that you do at the closing table. So that's why it's important when someone's doing a transaction, certainly from a real estate agent's perspective, is how do you want the deed titled? And when that question's asked, often that will then lead to a discussion of estate planning. So when you're buying what will be ultimately most people's largest assets, they should look to a law firm to do that planning and ask those types of questions. So I'm sitting next to my colleague, Bill Friedman. We've been friends for a long time, and now we have we're lucky enough to practice law together. So Bill's going to tell you a little bit about step-up and basis and like-kind exchanges.
So thank you, Anthony. One of the benefits of home ownership, and it goes to the government's encouragement in the tax code to promote home ownership, is that when a person passes and their house is left to whoever it's left to, whether it's their children or whoever specified in the will, that real estate asset transfers with what's called a step-up in basis at a stepped-up rate. So in other words, even if the house was purchased in 1970 for $50,000 and now it's worth $800,000, the basis of the house when the person dies is the value of the house at the date they died. So instead of having to pay a capital gains tax on that basis of $50,000 to $800,000, the heirs, if they sell the home, will only pay a basis of whatever the value of the house was at the date of death to the value of the house when it's sold. So in other words, capital gains are basically erased by the tax code when you're dealing with real estate that's left via will or intestacy. So that's a tremendous benefit. Most people aren't aware of it. I know people will sometimes say, well, shouldn't I shouldn't I deed my house to my children before I die? That way they get the house. And you know, we always say no, because you lose the step up. You'll be deeding the house to your children. You'll incur a massive capital gains tax that will have to be paid at some point. Best thing to do is to leave it in your name, devise it in your will to whomever's going to take it, and let them take advantage of the tax benefit. Now, when it comes to your non-primary residence, another advantage in the tax code is what they call the like-kind or 1031 exchange. And that allows you to take your non-primary residence and do what's called instead of just leaving it to an heir, you can do a 1031 like-kind exchange. So you take the value, whatever you would realize from that sale, it gets rolled into the next property. The capital gains tax is deferred, and you don't have to pay that capital gains tax until you sell your final property, right? So you can keep rolling it and rolling it and rolling it in 1031 like-kind exchanges. And what happens when you die? Well, that capital gains tax just goes away like it never happened. I don't know of anything else in the tax code that lets you just get away with something like that. So it's something to definitely consider from an estate planning standpoint. It's just such a powerful tool for avoiding what would be normally a rather massive tax burden. And I think that covers enlisting.
Do you have any questions at this point?
Yeah, so on the 1031, which is really interesting, amazing that, you know, that could happen. Now, I know there's a time limit, like when you sell homes and get to, can you talk about the time period, how much time you have to find your next home before the 1031 exchange expire in a sense?
I don't know the actual
I think
limit off the top of my head.
It's around 3 months, give or take.
Okay.
It's short.
It's a very short period of time, and there are a lot of people don't know there are vehicles out there that allow you to get the 1031 exchange benefits. If you invest, it's a real estate investment trust or REIT, and there are certain investment products that carry with it the status of a 1031 exchange. And so when you're selling your house, you can use those as a vehicle as well. But I know it's a very, very short window in relative terms, so it helps you have your ducks in a row, both on the sellers and buyer side, if that's what your objective is. That's a good segue. We were able to, and these questions as a sophisticated real estate agent, should come up. They can assist you with the sale. And it's a great segue. Everybody so far has talked about Florida. I'm going to share my screen and talk to you about a personal story with Florida. So, we were negotiating for the purchase of a property down there. We were pre-qualified. We had cash for the deal, and the people selling were going to move into a new place in Venice. And so they wanted out quick. And because we could close quickly, because of the 1031 exchange, we were able to close in a week, literally done deal. And we were able to realize probably the lowest purchase price in that development over the last 20 years. And why was it good for us? We got a low price. Why was it good for them? They realized the short window in the 1031 exchange, and they were able to then roll over their cost basis into their new property. It was win-win-win all around, and everybody was happy. You'll notice this is a Florida deed, if you will. It's really an assignment of lease. Well, you'll notice this was actually structured as joint tenants with rights of survivorship. The reason it was done this way in Florida is that there are probate fees in Florida. So in Florida, you want to avoid probate. So again, cost benefit. In New Jersey, you really want to take advantage of the probate process. So that's why there's different titling here versus there. And our firm is prepared to assist with all these levels of sophistication, as well as when you're relocating to another state.
That's fantastic. And also, Anthony, I know that your firm does other specialty as well. So you want to quickly just mention a couple of them that people know that you also do other real estate law?
Certainly, yes. We do. A lot of it touches and concerns. We do a lot of estate litigation. We litigate deeds. We do. So if there's a title issue, we'll file an action to quiet title, which if you're selling a property and these issues come up, we'd address them in litigation, get an order from the court saying that the deed is kosher or not, and settle title to allow the deal to go through. We engage in a variety of other aspects of litigation, like estate litigation, commercial litigation. We litigate in New York and New Jersey. We also do partition actions. So, for example, if you have two owners, one wants to sell, one wants to hold the property. Guess what? The one who wants to sell has legal rights to compel a sale. So, as a realtor, if you're faced with that scenario, you'd say, aha, I know that the person who wants to sell, as long as they have an interest in the property, they can compel a sale. You also have scenarios, a lot of people buy properties with LLCs and corporations. Typically, we see LLCs. And so when one wants to sell and the other won't, you file what's called an oppression action, an oppressed shareholder dispute, which results in the sale. So we have a lot of tools in our wheelhouse to allow for a positive outcome and a sale of properties when maybe you're having trouble with owners or trouble with title.
Excellent. Thank you so much for your time today. So if someone wants to get in touch with you with all the different real estate that you specialize, what is the best number and your contact information that they can get in touch with you?
Sure. It's highlighted in our screen below. It's 201-939-3304. It's also, you reach me by email, my first initial and last name, AGAETA @GaetaLawFirm.com. So look forward to hearing from everybody. And it's great working with you and your office, Simon. We've done a few deals before. One particularly long one, but it got done.
That's what happened with estate, right? That's what happened with it. Excellent. Thank you so much, and for your time. Please do get in touch with them with anything you have to do with estate planning, and also they also do tenants and landlord as well. So that's definitely, you want to get in touch with them.